All right, guys, welcome back. We're on to the actual. We're done with definitions. We're moving on. We're moving forward. All right, so 503.020 justification, a defense. In any prosecution for an offense, justification, as defined in this chapter, is a defense. Okay. Again, guys, like, subscribe, share, and I'm going to try to keep a lot of this under 10 minutes. So maybe one part, it may be two or three parts, it may be, I don't know yet. I'm running through these kind of fast. Just bear with me, okay? All right, statute number 503.03. Excuse me. Let me do this again. 503.030 or 030, excuse me. And this is called choice of evils. Unless inconsistent with the ensuing sections of this code defining justifiable use of physical force, or with some other provisions of law, conduct which would otherwise constitute an offense is justifiable when the defendant believes it to be necessary to avoid an imminent public or private injury greater than the injury which is sought to be prevented by the statute defining the offense charged, except that no justification can exist under this section for an intentional homicide. Excuse me. Number 2. When the defendant believes that conduct which would otherwise constitute an offense is necessary for the purpose described in subsection 1, which is what I just read, but is wanton or reckless in having such belief, or when the defendant is wanton or reckless in bringing about a situation requiring the conduct described in subsection 1. The justification afforded by this section is unavailable in a prosecution for any offense which wantonness or recklessness, as the case may be, suffices to establish culpability. All right, moving on, guys. All right, this is a 503.040 execution of public duty. Unless inconsistent with the ensuing sections of this code defining justifiable use of physical force, or with some other propositions of law, conduct which should otherwise constitute an offense is justifiable when it is required or authorized by a provision of law imposing a public duty or by a judicial decree. Number 2, the justification afforded by this subsection 1, which what I just read, applies when A. The defendant believes the conduct to be required or authorized by the judgment or direction of a competent court or tribunal, or in the lawful execution of legal process, notwithstanding lack of jurisdiction of the court or defect in the legal process. Or B. The defendant believes his conduct to be required or authorized to assist a public officer in the performance of his duties, notwithstanding that the officer exceeded his legal authority. Excuse me. Moving on. All right, this is section 503.050, use of physical force and self-protection, admissibility of evidence of prior acts of domestic violence and abuse. The use of physical force by a defendant upon another person is justifiable when the defendant believes that such force is necessary to protect himself against the use or imminent use of unlawful physical force by the other person. 2. The use of deadly physical force by a defendant upon another person is justifiable under subsection 1 only when the defendant believes that such force is necessary to protect himself against death, serious physical injury, kidnapping, sexual intercourse compelled by force or threat, felony involves the use of force, or under those circumstances permitted pursuant to KRS 503.055. Number 3. Any evidence presented to the defendant to establish existence of a prior act or acts of domestic violence and abuse as defined in KRS 403.720 by the person against whom the defendant is charged with employing physical force shall be admissible under this section. Number 4. A person does not have a duty to retreat prior to the use of deadly physical force. All right, moving on. (503.055) Use of defensive force regarding dwelling, residence, or occupied vehicle exceptions. A person is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to himself or herself or another when using defensive force that is intended or likely to cause death or great bodily harm to another if a person against whom the defense force was used was in the process of unlawfully and forcibly entering or had unlawfully and forcibly entered a dwelling, residence, or occupied vehicle, or if that person had removed or was attempting to remove another against that person's will from the dwelling, residence, or occupied vehicle, and b. the person who uses defensive force knew or had reason to believe that an unlawful and forcible entry or unlawful and forceful act was occurring or had occurred. Number 2. The presumption set forth in subsection 1 of this section does not apply if a. the person against whom the defensive force is used has the right to be in or is a lawful resident of the dwelling, residence, or vehicle, such as an owner, lessee, or title holder, and there is not an injunction for protection from domestic violence or a written pretrial supervision order of no contact against that person. B. The person sought to be removed is a child, grandchild, or otherwise in the lawful custody or under the lawful guardianship of the person against whom the defensive force is used. C. The person who uses defensive force is engaged in an unlawful activity or is using the dwelling, residence, or occupied vehicle to further an unlawful activity. Or D. The person against whom the defensive force is used is a peace officer, as defined in KRS 446.010, who enters or attempts to enter a dwelling, residence, or vehicle in the performance of his or her official duties, and the officer identified himself or herself in accordance with any applicable law, or the person using force knew or reasonably should have known that the person entering or attempting to enter was a peace officer. 3. A person who is not engaged in an unlawful activity and who is attacked in any other place where he or she has the right to be, has no duty to retreat, has the right to stand his or her ground and meet force with force, including deadly force, if he or she reasonably believes it is necessary to do so to prevent death or great bodily harm to himself or herself or another, to prevent the commission of a felony involving the use of force. Number 4. A person who is unlawfully and by force enters or attempts to enter a person's dwelling, residence, or occupied vehicle is presumed to be doing so with the intent to commit an unlawful act involving force or violence.